Hello and welcome again to Immigration News and Views. My name is David Nachman. I'm the managing attorney at the NPZ Law Group, Nachman, Fawani, Zimochek. We have offices in Ridgewood, New Jersey. We also have an office in Midtown Manhattan, and we have an office in Princeton, New Jersey. We have a new office opening in Indianapolis, Indiana, and we also have more on that to come. And we also have affiliated offices in Mumbai, India, in Gujarat, and we also have affiliated offices in Toronto and Montreal, Canada. Today I wanted to talk to you, since it's very, very close to October 1st. This is more geared toward individuals who are just starting on their H-1Bs. Obviously, if you were the beneficiary of one of the H-1B visas under the CAP, which was back in April, we did the filings in April for the October 1st start date. The October 1st start date opens the door to your being able to become H-1B on the payroll of your employer. So there are a couple of nuances I just wanted to discuss. I think first and foremost, and probably most important, as a quick tidbit for you human resource managers and professionals who may be watching this video, is that it's time to update your I-9 forms. If the individual was on your payroll and working for you in OPT status, obviously you know by operation of law, if the H-1B was approved, they continued their work authorization with you, and it's probably now time to update your I-9 form. You can either, of course, use the re-verification section on the I-9 form at the very bottom, or what you can do is you can do a new I-9 form and keep that I-9 form with the old I-9 form, keep them together and keep them in the I-9 files that you're maintaining. So that's number one. Number two, also, just to make all you human resource managers and human resource professionals aware, there is a provision in the law, it's in actually the Department of Labor regulations, which says that if you have an H-1B, the H-1Bs that are approved for the October 1st start date need to start on the payroll with the U.S. employer if these individuals are already in the United States within 60 days. So you have 60 days to onboard them. If the individual is coming in from outside the United States, you need to onboard them in 30 days. And the reason why the Department of Labor points that out is because they don't want employers to be benching employees, individuals who have H-1B, so there is this time constraint on the amount of time that the employer has before they have to put them onto the U.S. payroll. They don't want the employers to be using the time as a way to bench H-1Bs. So essentially an employer will begin to incur an ongoing wage obligation beginning either 60 days after the individual if the individual's in the United States and their H-1B takes effect on October 1st, within 60 days. Otherwise, if they're coming into the United States, it has to be within 30 days. So that's a little bit of a heads up. The other thing for our human resource professionals and our human resource managers who are viewing this tape, of course, normal labor and employment laws do apply with regard to onboarding of H-1Bs, so be aware that you need to be mindful of all the payroll issues. If you have non-disclosures and non-competition agreements, those need to be signed. If you have an individual who, let's say, started in OPT, it's not going to immediately come to your mind on October 1st that these individuals may have to sign non-disclosures, non-competes, and to do a new onboarding package with you. So obviously everyone's policies and protocols for onboarding are going to be different, but just be aware that obviously you have someone who's a student who's in OPT. Once they pass over that OPT into H-1B, then if it's your policy to re-onboard them, then obviously you want to just go ahead and do that. Now, one of the other issues, which is more immigration related, and this, of course, this point goes to both human resource managers and professionals, and also to the H-1B workers, who of course became H-1B workers on October 1st, is now is the time to start thinking about the green card. Don't wait. The green card process for many people is done through a process called PERM. PERM is the labor certification process, and it takes oftentimes a long time, many years, before the green card can be approved. So it's never too early to start. Now, as for some of you who may have seen me lecture at various universities and academic institutions across the country, you know that what I usually say is that OPT is the honeymoon period. It's the time when the employer and the employee get to know each other. And so is the first quarter in which you're in H-1B. But remember, we're coming up to the holiday time, and of course, it may be also bonus time, and the employer is going to call you in and they're going to give you an evaluation. So now is a good time for you to think about saying to the employer, thank you so much for that wonderful bonus you're giving me this year, but now is a great time for you to consider sponsorship for me. And let's consider doing the sponsorship through the labor certification process. Now, of course, if you're familiar with our videos, you know that there are other ways in which people can be sponsored. They can be sponsored through national interest waiver, they can be sponsored through outstanding researcher, they can be sponsored through extraordinary ability. These are pre-certified classifications and they go relatively quickly, but the vast majority of our clients go through the PERM labor certification process, and that process can take quite a long time. And it can take an especially long time for individuals from certain countries that are quota countries that are backlogged. For example, the Mexico, Philippines, India, and China. So if you're from any one of those countries, there is a very, very big incentive for you to start the green card process as soon as you possibly can. Now, of course, if you're also familiar with some of our other videos, you know that the American Competitiveness in the 21st Century Act has provisions that allow for you to extend your H-1B beyond the 6 years into the 7th year H-1B, and then of course if you have an approved I-140, you can extend it for 3 additional years, and so on. So obviously you may feel, okay, well I have the breathing room so I don't have to start the labor certification process immediately. However, it's always best for you to try, if you can, to initiate that green card process. Another thing that you need to be aware of is now that October 1st has rolled around, if you're not entering the United States as an H-1B, because you, let's say, were a student here and you don't have that visa stamp in your passport, and you're converting your status from OPT or F1 to H-1B, so you have a new I-94 and that's in your passport, but how are you going to travel? So there is a special procedure that's called, we call it visa stamping or consular processing. It's a service that our office provides if an individual needs to get the visa stamp, the H-1B, in his or her passport. So that's done by queuing up at the U.S. consulate abroad for the visa stamp, and that allows you to get the visa stamp to be able to travel to and from the United States. Now, oftentimes we get questions from our clients about the possibility of doing what's called third country processing. So for example, we have an individual from India who doesn't want to go back to India for the stamping because they've heard about 222Gs and administrative processing holds, where individuals, friends of theirs, may have been stuck at the U.S. consulate for many days or many months. Actually, we have some that we've heard about where it's been many years. And unfortunately, those administrative holds can be very, very difficult. And that's another service, of course, that our office provides, is that we can assist you to advance administrative hold cases if we understand why those cases may have been held at the U.S. consulates abroad. But either way, there is such a thing called third country processing. It is discretionary. It means that you have to reach out for the U.S. consulate and seek advance permission to go to that consulate in a country where you're not from. So for example, third country processing in Canada, third country processing in the Caribbean, or third country processing in any country in Western Europe if, for example, you happen to be there for a particular purpose. So many of our clients, for example, in the IT area, oftentimes are on temporary projects in Western Europe. Sometimes they have to go to Canada to do some work, and that gives us the opportunity to make an argument to the U.S. consulate that the individual, because they're there, should be allowed to get the visa stamp while they're there. So that's just a couple of issues which obviously human resource managers and our new H-1B employees need to be aware of. So of course we want to wish all of our H-1B clients the best of luck in their new jobs. And with that, we'll be back with more and additional information in the future. Thanks so much.